Hello. In this clip from our Justia webinar, Content Creator Law by a Content Creator, Julian Serafian will guide us through different areas where the legal industry plays a role within social media marketing, such as contracts, payments, defamation clauses, and more. If you want to see more Justia videos on law practice and legal marketing, please subscribe to our channel.
And now let's turn to the legal terms. Non-compete clauses. These are more or less straightforward. It's just like it sounds like. If a creator signs a non-compete clause with the brand, then it's saying that they're typically promising not to work with competing companies in the social media space for a period of time. There was one time, the first bullet point you'll see here, which was out of this universe. I saw it in a client agreement. It said you can never work in content creation again after this post. Bro, what? That's like absurd. That's saying that you quit the entire industry just for one brand deal. Absolutely crazy. I completely struck it, and the brand didn't fight me on it. I guess not surprisingly, but non-competes can get pretty egregious in that way because they're powerful. You know, they lock the creator in and limit their ability to work with other people. Most often, non-competes show up when it's bigger brands that are doing deals. We're talking like Sephora, Walmart, HelloFresh, like that level. And typically they're pretty limited in duration. I think I would say on average it's anywhere from 48 hours to a week of blackout non-compete time, and it's based on when the post actually goes live. So the language will say something like, the creator agrees not to work with any competing or post any sponsored products with the following competitors for the period of 48 hours before and after the sponsored post goes up. And then it lists all the competitors. So this example is definitely not common. You can never work in creation ever again. That was a story for the lore and for legend. Okay. Location of suit, jurisdiction of choice. I think many of you will probably know what this is intuitively, but if things do turn legal between the brand and the creator, where is the litigation going to have to happen? What type of law is going to govern the issue? That's governed by the location of suit, jurisdiction of choice clause. Typically, the company is going to write this clause in their favor. So it's going to say off the bat that the jurisdiction of choice is whatever city or state the company resides in. But that doesn't mean that it's not open to negotiating. Creators can certainly negotiate and push back on this and change the location. And I'd say in my practice, I have success in that about half the time when I actually want to change it for my creator clients. So I think brands are open to it, but you got to actually ask for it. This is one of those clauses that I think creators think they understand. They see it. They're like, yeah, I can read those words. Those mean something, but then that's it. There's no further analysis. And then they don't negotiate or push back on it, even though if they knew what it was doing, they'd probably push back on it. So back to our discussion earlier of like the importance of legal counsel, I think this is like one of those terms. But if they think they know that term, I can guarantee you creators have no idea what's going on with indemnification terms. This was one of the major sticking points that I had with my first brand deal agreement that I read. And I'm like, dude, this is obscene. How am I signing on to this? So let's talk about it. These clauses allow brands to be compensated, indemnified, reimbursed essentially by the creator in the off chance that the clients face legal action stemming from the creator's work done on the brand. So for example, I do a brand deal with Coca-Cola. I get paid $1,000. I post a video, me drinking Coca-Cola. Someone scrolling TikTok sees that ad. They are inspired to buy Coca-Cola. Wow, look at him. He's so happy drinking his Coca-Cola. I want a Coca-Cola. They go buy a Coca-Cola. As they're drinking the Coca-Cola, it explodes, sends shards of aluminum into their foot, breaks their laptop. They decide to sue Coca-Cola. Like, this is your fault. You're negligent. And in their lawsuit, they talk about how they bought it because of the advertisement where they saw me. Coca-Cola spends $500,000 defending itself, let's say successfully. An indemnification provision would typically allow for Coca-Cola to come after me, the creator, for $500,000. every single penny that they spent defending themselves. Even though the only money that I could have made from that relationship is $1,000 at most. No way I was going to make more. Maybe I could make less. I don't know. But there's no way I was going to make more than $1,000. But the downside is now I could be out 500 grand. And by the way, it could go higher. You know, if that person sues Coca-Cola and it goes to trial, and then they get awarded damages of $1 million and legal fees are $1 million, so $2 million total, they can come after me, Coca-Cola can, again, for the $2 million in damages and legal fees, simply because the creator, or the consumer rather, sorry, the consumer saw the ad that I had created, and because the contract that I signed with Coca-Cola had an indemnification clause in it. So these are very dangerous for creators. This clause is the thing that I think in the next 5 to 10 years, you're going to see a lot more action and recovery on, because right now brands, they don't want to be the bad guy and like bankrupt the creator for something, even though they probably technically could, but that's going to change. As the industry further develops, you're going to get bad actors, like really bad actors in our industry on the brand side who are not going to care about the repercussions, on the PR side, and they're going to invoke these clauses to come after creators. It's only a matter of time. So they're dangerous clauses. Indemnification, they have huge impact on the creators. Just the risk profile for what the creator is doing long term. And absent a cap on it, like we just talked about, the creator can be held responsible for the full amount of the lawsuit and lawyers' fees and damages, literally awarded damages, even if the influencer isn't really responsible. In the example we just talked about, why should I, as the creator who just advertised, is that my fault that the Coca-Cola can exploded? Like, no. Is there proximate causation because they saw my ad and then they bought it? Perhaps, but I think the fact that creators could even be on the hook for this at all is pretty crazy to think about. And yet, that's what a lot of these creators are signing on to. So generally, on the legal side, negotiating these provisions, what I try to do for clients is put a financial cap on how much money actually applies to the indemnification clause. For example, the influencer will indemnify you up to $5,000. We're not going to pay more than $5,000 in the event that this provision is invoked. This term, by the way, and you can see the language, the example language of these terms in the extra materials, but this is very dense legal language. For transactional attorneys who are sophisticated, experienced, it's one thing, but for the average creator or consumer, they're never going to be able to parse through this. They can read it 50 times, they're still not going to get it. Maybe that'll change now that we have like ChatGPT and it can help like explain things if people are actually resourceful enough to use it, but TBD. Okay. Usage and licensing rights. This I touched on earlier, but essentially licensing and usage rights. This is more licensing rather than usage, so I'm going to focus on that part of it. But we're talking about name, image, and likeness here. And this is it's very close to just as impactful as indemnification. Many a times the brands in these deals will want to use the creator's profile, their name, their face, to throw into their own marketing materials, their own website, just to show off. Like, look, everybody, we have this creator who's awesome and they like our product and they've endorsed it. I mean, that's, I think, a reasonable ask. What's not reasonable is when the term says that basically forever and ever, the brand can use the name, image, and likeness of the creator in any way they want, in perpetuity, however they want it, period. There's like no limitation to it. Why would they ask for that? Well, as we've talked about, this is a Wild West. Why wouldn't they ask for it? Brands, if they can benefit them, they're going to do it, right? But it's impactful and important for the creator because, I mean, that could theoretically give them a right to plaster the creator's face on Times Square, or who knows, billboards nationwide in a way that the creator doesn't like. I mean, maybe the creator changes their mind about the product and doesn't like it anymore. Maybe the product has a bad rep down the line, but if the creator doesn't have any way to stop it, that's a big problem. And more importantly, if they're not getting paid for it, that's not cool. That's not fair. Many creators don't really understand the value of these terms. They think that it's like just kind of should be included as a matter of course. But in reality, if brands are asking for a significant length of time, I would say like a year or longer for name, image, and likeness rights, brands will pay a premium for it if the creator asks for it. But creators need to know that they should have the right to ask for it. In any event, it's important that these clauses are closely reviewed and that the creator understands what they're signing on to, because this is very much a business decision for them. Do I want to let them use my name, image, lines for 6 months, for 12 months? Do I even want to let them use it at all? Maybe I don't. Many creators, they're very, very specific with how they want their brand to be portrayed and used. And sometimes that means they don't even want the brand to have that right. They'll do the piece of content for them, but that's it. They don't want anything else to, be out there. But, as you can imagine, many creators don't really understand what this is saying, so they sign away their rights at no additional cost. So whitelisting, this is more on the usage side rather than licensing, but whitelisting is when a creator will create a piece of content, they'll post it on their channel, and what a whitelisting term does is it authorizes the brand to push that piece of content through the influencer's account to different people. So instead of the content coming from Coca-Cola, let's use that example that I just went through with indemnification. Instead of Coca-Cola's profile pushing the ad, what it's going to actually say is Julian Serafian. It's going to be my post, and it's going to be coming up as a sponsored post. It's going to be like a paid ad. The reality is it's not me paying for it, it's Coca-Cola paying for it. And companies do this for a variety of reasons, but a main one is that it looks and feels more approachable to a consumer. That's the theory, at least. If it's Coca-Cola giving you something, like obviously it's an ad. It's Coca-Cola's profile. What the hell else are they going to be sending you? What, saving your life, sending you life-saving medical advice or legal advice? No, they're showing you Coca-Cola. Be happy. But when it comes from Julian Serafian, suddenly, it's a human being. It's a creator. Maybe this is something worth watching. Maybe, there's value here. So I'll watch it because I feel more connected. So whitelisting is something that's typically negotiated between the brand and the creator. Creators can go either way on this, I've noticed. Frankly, I don't mind whitelisting because what the brand's offering to do is boost my video and get my face out to more people. Like, I'm fine with that. I have no problem with it. There's still value in it, so I'll negotiate a price for it. But many creators are very, very protective of their brand, like I said earlier. And the thought of their face being pushed out as a paid ad to people that aren't in their audience, because the people that are being targeted by this are most likely just folks that check the boxes of certain demographics that the advertiser is saying on their end that they want. That doesn't sit well with a lot of people. So if whitelisting is included, typically it's financially compensated for. Anywhere from, I would say, 20 to 40% of the overall brand deal. That's how much money whitelisting on its own is worth. And, as a common theme in this lecture, as I'm sure you've picked up on, this is another term that influencers don't really understand that they should be limiting or charging extra for, so they just give it away. Morals clauses are on the rise. And these are essentially ways for the brand to protect themselves in the event that the creator does something to get themselves canceled. And the brand wants power over either paying the creator or having the creator take down the content. And the language can be very broad, but in general, what it gets at is something that the creator does that is immoral or morally reprehensible. I have issue with some of these, just as an aside, because they say politics, like they literally say anything that's bad, blah, 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 including, and then politics. One time it said reproductive rights, aka abortion. It's like, I understand that politics can be messy and aggressive and controversial, but to equate politics and reproductive rights with doing something immoral or morally reprehensible, that's just not it. That's not appropriate. That's not correct. And it kind of amounts in some respects to censorship. However, this is business. This isn't politics. So the brand has every right to ask for that. And if the creator signs on to it, they sign on to it. I will say also that most often creators are not political. They stay away from politics because of how divisive it is and controversial and perhaps not great for their content creation business. But anyway, morals clauses, they're on the rise. I think they're going to get bigger and more popular over time because it's a simple way for the brand to feel like they're protecting themselves. And in general, of course, the narrower this clause, the better. Okay, we're almost out of time here, so let me run through these real quick. Limitation of liability is pretty straightforward. It caps the financial amount of damages that can be recovered by either side if a legal dispute arises under the contract. So I think it's wonderful for creators because, now it can cap, for example, their liability under the indemnification clause we talked about earlier. I think that's great. I should say these show up in about half of cases, half of brand deals that I review. So it's not the most standard, but I love it when I see it, and I add it in to my creators agreements when I think it's appropriate as well. Okay, so last topic I want to touch on. Everything we've just talked about has been in the context of brand deal contracts and the legal terms governing them, but there's a whole other sector of law of legal work that's been on the rise in the creator economy, and that's defamation suits. This typically happens when there's influencer drama. So, here's a typical fact pattern. Influencer A says X. Influencer B says that's not true. Influencer A says it is. Influencer B then sends A a cease and desist threatening defamation litigation if they don't take their post down. And then I get a phone call from influencer A saying, I got a cease and desist. I don't know what to do. I'm panicking. What do I do? What do I do? And I had no idea this was even happening when I entered the industry as an attorney for creators, but I just got more and more of these cases over time because it keeps happening. Sometimes it's not between influencers. It could be between a brand and an influencer. One of the benefits I think of social media is everybody has the microphone now. So you can go on there and be like, this dog hotel abused my dog. This is what happened with a client. They abused my dog. Here's the video evidence. Here's them saying that they were going to get me camera footage and they didn't. This is horrible. And then millions of views. And people millennials love dogs. Gen Z even more. So people just went ham on the Yelp page, the Google Maps page. They just one-starred it over and over and over. They tanked the social media profile of that brand. And then the brand sent the cease and desist to my client. And, most of the time these cases don't go to trial. They're settled either because one side will give up and stop threatening the cease and desist or defamation litigation, or the creator who is being asked to take down their post will honor the request, take down the post, and then move on. There's ethical implications to this issue. When somebody threatens a lawsuit and then that's enough for the creator to fold and take down their video, that's censorship. That's weaponizing the legal system. That's not something that we should allow. But it happens. It happens even to clients that I have, even though they have me, because I realistically tell them, look, if you want to defend yourself against this, it's going to cost a lot of money and it's going to cause a lot of stress. Is that worth it to you to keep the video up? Alternatively, you can take the video down and then the problem goes away. And I'm just being practically minded about it at that point. But at the same time, that's unfortunate that the legal system is still in such an arcane place that we allow that sort of thing to happen, and we allow folks to be silenced like that. So in any event, I think this area of creator law will continue to be an ongoing issue. And I certainly think it'll continue heating up because more and more people are getting on these platforms and becoming creators. More and more people are being inspired to use their voice as they should. And with that comes people who don't like the things that they're saying. Such is life. Okay. That is it for me in this webinar lecture CLE on law in the creator economy. I sincerely hope that you enjoyed this and you walk away with a new perspective the next time you see an advertisement on your social media feed. If nothing else, I do want you to know that social media is incredibly powerful. It's powerful as a creator. It's powerful for business. It's powerful even for attorneys. It's not going anywhere. It's only going to get more and more prevalent and powerful, even if at the same time, on the mental health side, it is terrible for our mental health. It makes us more lonely. It distorts our sense of reality. And it gives us a false belief that other people are always having fun, and on top of the fact that it's just constant dopamine hits short term rather than like deep thinking. So it's a double-edged sword, but that doesn't mean we cannot learn about it and take it seriously, because it's here to stay, and the money and the power in it cannot be understated. If you ever need anything from me, feel free to reach out. I believe my contact information is going to be listed here, but if it's not here, you can find me online. I'm on LinkedIn. I'm on, obviously social media, TikTok, YouTube, Instagram, and I hope to see you around someday. Be well out there. Take care.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.